Hey, everybody, how's it going? This is Seth Williams. I'm talking here with Amanda Wynalda of Anderson Business Advisors. Amanda was kind enough to sit down with me because I have a bunch of legal entity formation questions. These are questions that I have had many times over the years, and I've gotten some of them answered, but some of them not. And I also hear a lot of other people in our community ask these same questions. So rather than me trying to pretend I know the answer, I thought, why don't we talk with somebody who's really smart and get the answer directly from them? And they're also an attorney, so they can give this kind of feedback. So, Amanda, how's it going?
Good, good. Thank you for having me.
Yeah, absolutely. So, one of the big questions that I hear about a lot is this question of, let's say I form a business entity in my home state, but I'm going to buy and sell vacant land. I'm going to flip that vacant land. So I'm not going to buy and hold it. It's not like a rental property. I'm going to quickly buy it and sell it in another state, a different state than where my LLC is registered. At what point do I need to either form a new LLC in that state or register my original LLC as a foreign entity in that state? What's the official line on like, now you have to do it, now you don't have to do it, that kind of thing?
Yeah, unfortunately, official lines in the legal world just don't usually exist. You get a lot of
I was afraid you'd say that.
it depends is the attorney answer. So it will depend a lot on where you're investing in land. One of the key things to know is that LLCs need to be registered in a state when they're doing business in that state. Now, what is doing business in a state? Well, that's going to vary from state to state. So, very obvious things are if you set up a store and you're selling things, but in the terms of real estate, that line can be kind of gray. So, if you're just purchasing property, holding on to it, flipping it, not doing any kind of construction, so especially if it's raw land, then you're not going to be considered doing business in the state. So you can likely close on the property with your state specific LLC and not have to foreign file it. Or alternatively, as you mentioned, set up a whole new LLC in that state. That does come with caveats. So if you're doing non-traditional financing, if you're doing seller financing, if you've got hard money loans, those types of lenders don't really care. If you're using traditional financing, like a standard loan, then the title company's involved. And when you get title companies involved, banks involved, then they're going to have their own internal guidelines that they want you to follow. So we have clients who are technically not doing business in a state, but their title company won't allow them to close in that LLC unless the LLC is registered. And they'll actually go and register that LLC in the state for you. That can be good or can be bad depending on what your goals are. So it's kind of a hard question to answer. Again, it depends, but for the most part, raw land, non-traditional financing, you're not going to need to register that entity in the state. When you start to do more is when you start to have to think about doing that.
Yeah, and what is considered more, like subdividing it or developing it or holding it long term or?
Sure. Developing, definitely. Renting is typically considered doing business in a state, so you're going to want to register there. In reality, there's sort of what the statutes say, and then sort of like what happens in practice. So the statute's going to say doing business, right? But can you get away with not registering your entity in the state for a while? Sure, as long as you don't run into any problems. The problem comes when in real estate, it's always when you get sued, right? Not if you're going to get sued, when you get sued. If you start working with contractors, if you start entering into contracts, if you start needing to sort of assert your legal rights within that state, then that LLC is not going to have any way to do that. LLCs are able to what's called avail themselves of the court system within the state by paying that registration fee, having a registered agent in that state, being on file with the Secretary of State. You are saying, I'm doing business here, so I can also assert my rights in the same place. So as long as you don't have to do that, a lot of people don't end up even registering their LLCs until they run into an issue. And then you can just file with the state, take someone to court, that type of thing.
So earlier you had said that sometimes your title company might make you register. So is it possible that you don't even technically need to do it, but your title company just wants you to? Like, does that ever happen? Or it's not technically a legal issue, but they just feel more comfortable that way?
Sure. If you're buying a property, and let's let's just go with like a residential real estate, because that's most likely scenario you're going to be using traditional financing. Simply owning a property in a state is not considered doing business. You're not actually doing business until you rent it out or until you're using it to make money off of it, until you're using it as business property. So you technically don't have to register just to purchase, but the title company, the lender, wants to see that entity registered in the state where the property is located.
Gotcha. So technically, one rental property making $1 in rental income, that's doing business?
Yep.
Is that accurate, or is that?
Mm-hmm.
Gotcha. And I guess when it comes to flipping land, for example, or flipping a house or flipping anything where there's not rent, but the money isn't made until you sell, that's the point at which you would trigger the need to register that thing.
Yeah, you may. When you're the seller, you don't have as many restrictions on you. Especially if you're doing land and you're doing maybe seller financing, so you're making the rules, right? So you don't put that onus on yourself. If you are, the title company is not going to be as concerned as to how you hold title and they're going to want to see your filed articles. They're going to want to see that you personally have the right to control this business, sell this property, but it's not going to be as concerned that you're actually registered in the state, because once the sale's done, you're no longer there, right? So the problem would be if you ended up needing to sue upon that sales contract or enforce some right or privilege that you have through the contract. You wouldn't be able to do that until you register your entity.
Now, this issue of like, what if you don't? What if you don't register or something goes wrong?
Right.
Do you, like, what is the consequence of that? Do you, like, for example, can people pierce the corporate veil? Like, it's as if you don't even have an LLC, they can get your personal assets, or is it just you can't go after somebody and start suing other people?
It's going to be the latter.
Okay.
Your LLC still legally exists in another state, and so under the full faith and credit clause of the U.S. Constitution, each state has to give full faith and credit to legal entities that were created under another state's law. So that's why a notarization in one state is valid in another state. That's why a judgment in one state can be enforced in another state. So it's really the second thing, that if you get sued for breach of contract, you can go in and defend yourself without registering, but you can't countersue for breach of contract. So you're basically just saying, no, I didn't breach, but you can't turn around and say, it's actually them that breached. I need my damages. I need to be made whole again. So that's where you run into the issue. Gotcha.
And I know an alternative to registering your LLC as a foreign corporation is to just start a new LLC. So I guess the reason you want to register as a foreign corp is maybe if you already bought a property in that other state's LLC. So like it's already done. You just have to register that one.
Mm-hmm.
But if you say, if I'm making a strategic decision to go into another state and I have the intent of doing lots of deals there, in that case, do you think it's better to file as a foreign entity there or just start a new LLC? Like what would be the pros and cons of each one?
So there's a couple of things to think about. Here at Anderson, there's always the good, better, best strategy. So the best is going to be the absolute most asset protection you can have. The balance of that is that that's not inexpensive to maintain. Every state that your LLC is registered in, you're paying for a registered agent. You're paying an annual filing fee, which varies from $50 to Nevada, where I'm at, is quite expensive. It's $450 to maintain an LLC annually. And then even just the cost of setting up those entities. So we at Anderson have a titanium program that for an upfront cost, you can set up as many entities as you want. So if you were a titanium client, I would say, yeah, let's just set up a new entity. There's no reason to use the same one and commingle the liability of different properties into the one entity. Let's spread it out to what you're comfortable with, what you can maintain throughout the year, so as to limit that liability
Gotcha.
issue right there.
So I have a pretty loaded question I'm going to ask here. But
sure.
So I always hear about like Nevada LLCs, Wyoming, Delaware, these like hot button states. What's so special about having an LLC in these states? And which of those is the best to have for somebody who's flipping land? Any ideas on that?
Sure. So states can have different rules for different type of entities. A place like Delaware, which is very close to New York, wanted to draw businesses to Delaware, so they made their laws very business friendly. I don't exactly know why Wyoming ends up being a hotbed, but maybe if you don't have a lot of other ways to draw businesses to your state, you have more favorable laws. It's a loaded question in that typically blue states have less business friendly rules and red states tend to have more business friendly rules. Between Nevada, Delaware, and Wyoming are going to be the big three that you always hear of. Nevada, the one downside I see here is that the Secretary of State publishes manager and member information and corporate director information. So if you're doing a type of passive real estate investing, if you want to stay anonymous, be sort of that faceless business landlord, not let anybody sort of know how big your portfolio is, Nevada's not necessarily the place to have your like holding company, your parent company, because your name's going to be right on there. Wyoming and Delaware have those anonymity protections. So if you go look up, like I have a holding company in Wyoming, I'm not going to tell you what the name is.
Come on.
But if you knew it, you could look it up and you wouldn't be able to tell that I owned it because all you see is a business address, right? Delaware's the same way. Delaware's typically for larger corporations, so the corporate law is more robust there. So if you're planning to scale to the size where you're selling shares or getting outside investors, then Delaware might be the way to go. Wyoming is where we have infrastructure. So sort of the short answer is that that's where we can be of most help to our clients. We have an RA office there. We have a mail forwarding office there. We keep all corporate documents there. So your membership certificates, we have you sign them, execute them. We keep them up in Wyoming. So you get that charging order protection. There's case law sort of piercing the veil and not giving that protection if the membership certificates or corporate stock certificates are not actually kept in the state where the business is located. So we have infrastructure to support our clients there. And then Wyoming's just less expensive. Like I said, corporation in Nevada is $650, an LLC is $450. In Wyoming, the annual registration fee for an LLC is $62. So it's well under $250 to maintain as many Wyoming LLCs as you want.
Say if I'm flipping land in a state that's not Wyoming, but it's a Wyoming LLC, I have to then register that as a foreign entity wherever I'm repeatedly doing business at, correct? Based on what we've mentioned?
It depends. So the structure we recommend for flipping is going to be a corporate structure because you get more deductions there because you have the just the flat 21% tax. For a lot of people who are very big into real estate, their tax bracket can push up to 34, 37%. So you're getting that lower tax there. And then we have you have your main corporation wherever you live so that you can pay yourself a salary, so you could set up a retirement plan, those types of things. An entity has to be registered wherever it's paying employees. So if you're the first employee, you want your corporation to be where you live. And then you could set up a subsidiary LLC for each flip that you're doing in whatever state that you're doing in. And the benefit of doing one LLC per flip is that you do that flip, you're protected within that LLC. It's disregarded for tax purposes. So all the income and expenses flow up to your main corporation. So you don't need like separate credit cards for every flip. You can still use your main corporate account at Home Depot or whatever, get all those benefits. And then you sell the property and then you just shut down that LLC and it's gone. And if the buyer wants to come back and sue your entity, the seller, well, it no longer exists. So it makes it very, very difficult. It's this extra hurdle that just gives you as the investor a little bit more protection.
Just to make sure I heard you right.
Sure.
So if I lived in Michigan and I set up a Wyoming LLC, I would want to register that entity as a foreign entity in Michigan where I'm paying myself, right?
Yeah. So let's backpedal a little bit. So when I talk about anonymity and the benefits that Delaware or Wyoming give to an investor, anonymity, you're really looking at your passive real estate investments. So you've got your rentals, your long-term holds, things that maybe you're seller financing, so you're earning interest, things that you're not actively out there pounding the pavement for. When we're talking about a corporation, we're talking about active income. So that's flipping, that's wholesaling, that's Airbnb. Those are the types of things you're not necessarily concerned about anonymity because, as you well know, having your face is your brand in real estate. You are your business. So not owning your business or not making it look like you own your business on the record just isn't really that helpful. So that entity, the one that's doing the active investing, that's getting active income, that's going to be where you're located with subsidiary LLCs wherever your properties are. You're in Michigan, you've got a Michigan corporation, you're flipping in Iowa, you're flipping in Indiana, you're setting up individual subsidiary LLCs in those states. But for your passive investing, you're getting a holding company in Wyoming, a couple of states we may do a Delaware, because Delaware has series LLCs, which is a whole other thing to get into. But for that, then you're holding each rental property in a state-specific LLC, and then it's flowing up to your holding company. But your holding company, the anonymous part of your structure, the one that keeps that corporate veil, that keeps that anonymity shield between you and your investments, that will always stay in Wyoming, because that will always keep your name off the public record, and that will always give you the charging order protection that's so important. And then from there, you do a subsidiary LLC to hold each rental property that you have in whatever state where the property is located.
Okay, so Wyoming is mostly about anonymity, right? If you don't care about anonymity, then there's not much of a reason to do it there.
Yeah,
Right.
exactly. So if you don't care about anonymity, or if you're more of an active investor, you're not holding any properties off to the side as passive, then you don't necessarily need the holding company structure. So if you're flipping, sometimes you're just starting out with a corp. So if you're in Michigan, you've got your corp, you've got a subsidiary LLC for maybe a Michigan property, another one for a Texas property, wherever you happen to be. Alternatively, you could foreign file that corporation into the individual states if you wanted to just flip everything within the one corp. But again, you're balancing having only one entity, although it is paying filing fees in each state. But if you don't want to have to do annual meeting minutes, that's basically the extent of the legal compliance you have to complete for an LLC. So if you just want the one entity and you're doing 100 flips in it, just know that if one of those flips goes bad, it's potentially affecting all of it, because all the assets are held in the one entity.
And was I understanding right that if we go back a few minutes and let's assume I'm registering in Wyoming because I care about anonymity for whatever reason, were you saying to then have subsidiary LLCs in each state where you're working that are owned by the Wyoming one?
Yeah, so for anonymity and the Wyoming holding company, you're looking at passive real estate investing, so your rental properties. So whatever state your property is in, because remember, renting is doing business in the state, you don't want to register your Wyoming entity in every state, because then you lose that anonymity. Like I said, in Nevada, it has great asset protection, but it doesn't have anonymity. I have an LLC with my husband in Nevada that we do like 1099 work out of. He's like the face of the company kind of situation. So our names are just on that entity. So we would never hold property in that entity. We don't want people to know the size of our portfolio. You don't want people to get rear-ended by you and then look your name up and see property all over the place with your name on it. Puts that just target on your back. So for that, you're leaving your Wyoming entity in Wyoming, and then the state where the property is located, that's where you have a separate LLC that's owned by the Wyoming entity, because like I said, renting is doing business in the state.
Mm-hmm. Okay, gotcha. And you may have already mentioned this, but what is the benefit of Nevada again? If Wyoming is all about anonymity, why do people do Nevada?
There's no state tax here.
Okay, gotcha. So the income tax, you mean?
Yeah, there's no state income tax. There's charging order protection. So charging order protection means that if you go out and you personally get sued, you get in a car accident, you go through the whole process, your insurance doesn't cover it, you owe this big judgment. Charging order is the only remedy for your creditor. So they can't pierce the corporate veil. They put a charging order on your entity, meaning that anytime your entity distributes funds to you, then they can garnish those funds. But you're not forced to distribute anything. So you could potentially leave all of your earnings within your company and continue to buy more property, continue to build wealth, continue to do hard money lending, continue to flip whatever it is. And as long as you don't make a distribution to yourself, then that creditor is not going to get it. Will you still have to pay that judgment? Sure. You can just pay with whatever W-2 salary you have. There's limitations on how much of your salary can be garnished by a creditor. But you're sort of just giving them enough so that but still being able to build wealth over here on the side. So Nevada, Delaware, Wyoming, they all have this charging order protection.
Just like looking at Wyoming versus Nevada. Wyoming is cheaper and you get the anonymity. So why would you go with Nevada if you get the same cheaper benefits in Wyoming? Is the income tax thing? Is that what it is?
Yeah, there's state income tax. People, it's just one of those things that, I mean, I don't know how old you are, but maybe I'm dating myself. But like back when you heard something in elementary school and there was no internet and no Alexa to ask, you just sort of believed it. And then you told the next person, you told the next person. It's sort of one of those things where everyone's just thought Nevada is a great place to do business. And it's like, well, yeah, sure. If you live in California, then definitely come here, do business. You're going to pay a lot less in taxes. But if you're looking for all these key nuances that are specific to real estate investors, really, then it's not always the best place. Like I personally have a rental here in Nevada. I don't even put it in a Nevada LLC. I use a land trust to a Wyoming LLC because it's much less expensive to maintain. It cuts into my cash flow too much to have the Nevada LLC.
Yeah, gotcha. And by the way, for everybody listening and watching to this, and we'll get into this a little bit more later, but if you guys ever want to get like actual legal advice and work with an attorney like Amanda, Anderson Business Advisors, this is what they do. Like they're specialists in all 50 states. We have an affiliate link with them. I'll include that beneath this video. It's retipster.com/ABA for Anderson Business Advisors. And you can go through that, help support REtipster and get some awesome like one-on-one specialized advice from these guys. So now you had mentioned something about for flippers, you recommend a corporate structure. Do you mean like an LLC taxed as an S Corp, or do you mean like a C Corp or something else? Like what does that mean exactly?
Sure. From a lot of it is because of tax. So tax reasons, sort of the main focus on why we recommend the C Corporation. From a tax perspective, an LLC taxed as a C Corp is no different than a traditional C Corp. The difference is that you have membership interest. So if you and I partner in a corporation, we have 50% and 50% membership interest versus a traditional corp, you have shares. So we authorize a certain number of shares. We issue a certain number of shares. So maybe you have 500 shares and I have 500 shares. And you can then sell off more shares to more people. So I always say, if you're planning to scale and grow to the extent that you're wanting to sell off pieces of your company, then maybe we go with the traditional corporation because it's much easier to piece that out by either authorizing or issuing more shares. And people understand that conceptually, like I'm putting $100,000 in and I'm getting X number of shares versus the percentages can get wonky when you initially start, and then the more people you add, that sort of dilutes everybody's things. Ownership interest. So that's really the only difference. So yeah, when I'm talking about flipping in a C Corp, that's really just depends. A traditional corp or an LLC taxes a C Corp. An S Corp is also another option. An S Corp is not a separate tax-paying entity. It files a tax return, but ultimately it issues a K-1. That K-1 you report on your personal return. So it all flows through to you, which can have varying levels of tax consequences for your personal return. So that's sort of something that on the tax side of Anderson, we would run scenarios to decide, okay, we're starting you with a corp. A lot of times that's because real estate investors, they really go for it. They buy training programs, they get with people to be mentored, and that can sometimes cost a lot of money out of pocket. A C Corp is the only way to recoup those expenses. You cannot take those education expenses on even an existing real estate business unless that education is required to maintain a license. So for example, I have to take CLEs every year to maintain my bar license. Those I could deduct on my law company if I had one. If I had a separate company, Anderson's great because they reimburse us for that kind of stuff. But on just a separate entity, even if I'm already in real estate, that's not going to be deductible. So if you're shelling out tens of thousands of dollars to get this vital information from people who've been there, a C Corp is really only way to carry forward those losses. And then say you spend $20,000. Well, the first $20,000 that you make is completely tax-free. Does that mean that down the road you're making an S election? Maybe that works better for you in terms of your personal tax rate. Maybe the corporate tax rate goes through the roof for some reason, we can always make adjustments as we go along.
So in terms of like liability protection, that doesn't really change anything. We're talking purely about tax consequences based on, gotcha. And that probably depends on maybe how many people are involved. Like if it's just one person and that's it, like does an LLC make sense in that case? Or you're thinking always go with a C Corp no matter what?
It doesn't really matter for the number of people. I'll give the example of Nevada again. So in Nevada, an LLC costs $450 annually and a corporation costs $650. So we're going to set you up with an LLC, and then with the IRS, we're going to make an election to have you taxed like a C Corp. But at the state level, for legal purposes, you're an LLC, so you're only paying $450 versus setting up a traditional C corporation. Well, now you're paying $650. It's not a ton of money. It's not a ton of difference. It's probably one of the larger differences if I look at all the filing fees across the state, but it makes a difference. It's something you do have to pay every year. So,
not that it's kind of a random thing, but I had heard that there is a wholesaling maneuver you can do where you buy a property in an LLC, but instead of selling the property and signing a deed, you sell the LLC that owns that property. When and why would a person want to do that? Does it mean they don't have to pay transfer tax or something? Or is there some other consequence? Or like, what's the when and why of why people would do that?
Yeah, I would love to say that it gets you out of the transfer tax, but it just doesn't. A lot of the transfer tax statutes will say a 50% change in ownership gets hit with transfer tax, or a 50% change in ownership of the business entity that owns the property. So you're not going to get around the transfer tax, but what it does do is it keeps your name off the public record, keeps your personal name off the chain of title, because those corporate documents are private documents for the most part. The only thing that's being recorded is the annual filing with the state. So if you're in a state that doesn't report manager or member information, then I could sell you, like if we had a property in Wyoming, I own an LLC, you can't see my name on it, I sell you the entire LLC, I basically execute a 3-page piece of paper that says I assign 100% of my interest from Amanda to Seth. You own it now. You are now responsible for updating the filing and paying the property taxes, but in no way can anyone look at the property and say, okay, who owns this? I don't know, this entity. Did it even change hands? Nobody really knows. Does that mean you're get out of paying the transfer tax? The onus is still on you to go to the tax assessor, pay the tax, even though there's not a new deed filing. That's sometimes a little awkward because as a real estate investor, you're used to having to pay that tax because of the deed filing. Without the deed filing, that doesn't necessarily get you out of paying the transfer tax.
I guess that might be another issue with anonymity. So if you really don't want your name to be traceable as the owner of that LLC, Wyoming would check that box. But other states where the name does show up, it might not check that box, right?
Right.
Gotcha. And there's the land trust. Is that a way to do this without, triggering transfer tax and that kind of thing? Or is that a similar issue with selling the LLC?
It's a little bit different. So a land trust is a statutorily created revocable grantor trust in Illinois or Florida. So in Florida, land trusts are widely used because they do offer asset protection. So if you're the beneficiary of the trust and the property's sued, normally you'd be liable for that judgment. But with a Florida land trust, you aren't. They built into the statute some asset protection there. We do land trusts in all 50 states. We call them land trusts because to distinguish from the different types of trusts we do, because we do estate planning, so we do living trusts, we have personal property trusts. So a land trust is sort of what we just call it. In 48 other states, it's not technically a land trust. It's not capital L, capital T. It's lowercase l, lowercase t. So it's really just a revocable grantor trust. Revocable means the grantor can take the property back versus an irrevocable trust. And a grantor trust means that the grantor and the beneficiary are the same party. So we actually use land trusts a lot to avoid the transfer tax because even in counties that are a little more stringent, they will ask for the trust documents to make sure that the grantor and the beneficiary are the same party, but they don't put that up on the public record. So you'll have a deed. It's showing it's transferred to the name of the trust. The name of the trust is generic. The name of the trustee is generic. And then the actual trust agreement is nowhere on the public record. And then from there, you can assign your beneficial interest. So you can essentially make an LLC the beneficiary instead of yourself, so that if that property in the trust is ever sued, that entity is responsible for the judgment. And that entity doesn't have anything else in it except for that one property. So your entire rest of your portfolio is safe. And then that transfer of beneficial ownership is not filed anywhere, is not recorded anywhere. It's just in your personal file cabinet over to the side, so it doesn't incur any transfer taxes. And many of the states don't even have, they have an exception for putting property to a revocable grantor trust, and then they have either no provision or are silent on whether or not changing the beneficiary is a transfer. So you get out of that way.
And this is kind of a random question, but if your LLC is registered in a particular state, so I don't know, if I just opened up a Tennessee LLC or something like that, does that mean that your physical mailing address needs to be in that state as well? Or do you need to maintain any physical presence other than just the properties you buy and sell there?
It depends on the state.
Okay.
So some states will require, as part of the filing, that you show an in-state address. A lot of times you can just use the registered agent address for that. So at Anderson, we have registered agents in all 50 states. So you can easily use our address for that. You don't have to have a virtual office, or, I mean, I guess essentially it's a virtual office service that we provide, but you don't have to have a mailing address there. So the answer is sort of, it depends. We have this giant resource spreadsheet and someone who keeps track of that and updates it, so we can easily answer that question for you.
So it sounds like it's mostly boils down to the registered agent if you've got one.
Yeah, for the most part, you're going to use the registered agent. The problem with that, so I work at Anderson and I set up an entity and I was like, oh, Anderson charges $135 for a registered agent. That seems kind of a lot. Like, I can go online, find a $25 registered agent just online and use them. The problem is that they then give you 5 free pieces of mail. They let you see 5 pieces of mail for free, and then they charge you $15 for every piece of mail to see. And most of it's junk. Most of it's just stuff that when the property owner changes and you're just like, this is either a scam, some like deed surveillance thing, but once in a while it's something you actually need. It's like a notice on utilities, or it's something really important, property tax notice. So you can't not pay that $15. And what I found after a year of doing that was that the Anderson fee, even though it's a little more expensive initially, we do free mail forwarding. Everything just gets uploaded to the cloud for you to easily look at, and it ends up being way less expensive. So, but in answer to your original question, if you need an in-state address, that registered agent address is always available. And the registered agent is in the state because that's what they're there for. It's a place that each business entity identifies as a place where people who want to sue that business entity can serve paperwork.
Okay, gotcha.
So that's what it's there for.
So I know there's a lot of different services out there, like, I don't know, Rocket Lawyer, My Corporation, CorpNet, that can do all these like LLC, S Corp filings for you if you want to do it super cheap. And they can also do the registered agent stuff and DBAs and all this. So why use Anderson Business Advisors instead of just that? Is it mostly about the advice and like understanding your individual situation and advising you? Or is there, I know sounds like there's the registered agent service, but what are the reasons why somebody would want to consider paying more for Anderson Business Advisors?
Sure, we get that a lot. I mean,
yeah.
Even before I became a lawyer, I started an LLC on LegalZoom, and it's a super easy process. You go through, you answer some questions, you get a binder and a little stampy thing in the mail, and you're like, cool, thank you. And I put it on a shelf and like never looked at it ever again. The problem is that I didn't understand the questions that were being asked, so I gave the answers I thought would make sense, and looking back on it now, they were completely wrong. So with those types of services, you're not getting a custom drafted operating agreement. There are little things that you need to have in your operating agreement to make your asset protection structure work smoothly. And then in addition to that, we provide all the support. Like, we give you instructions on how to maintain your entity, how to open a bank account. If you have trouble opening a bank account, we've seen that. We can sort of give you the tips and tricks on what to do, even for something simple like that. And then on top of that, like you said, we have all the ancillary services. We have the virtual office services. We have our platinum program where you can call into a hotline and talk to an attorney the same day. Like people who pay thousands of dollars in retainers can't pick up the phone and talk to their attorney the same day. You're like, hey, can I schedule with you sometime next month? So we actually have that service. You can submit questions to our tax pros. And then we do have tax and legal under the same roof. And that was what initially attracted me to working at Anderson, because I have a tax background in law school. I had a entertainment background. Before that, I went to law school in California. And for some reason, I just thought entertainment law was completely boring and tax law was super fascinating. So Anderson has both of those things under one roof. Not saying that you will get a single person that knows all of the tax and all of the legal, but I can easily walk next door and ask our head tax consultant a more complicated question and get you an answer, versus you having to be the one interpreting between two professionals that frankly don't speak the same language. So that's really what Anderson offers. It's the total package. It's having been there. Our three partners have been investing in real estate specifically for 40 years. And so they've kind of seen what you've gone through. They encourage all the employees to invest in real estate. Our Clint says, you guys want to know how hard it is to maintain a corp? Why don't you guys just start a corp, and then you'll know what the client is having to go through in terms of doing an annual shareholders meeting, an annual directors meeting. So you're getting sort of that real estate guru type of experience, but with that tax and that legal background.
No, it's a big deal. I know from experience, like when you've got one party doing the legal stuff and one party doing the accounting, like it can get very disconnected, and like they don't really understand what the other is saying. And to have all that under one roof, I can totally see the synergy and benefit to that. So awesome. Well, Amanda, thank you very much for your time. You've been very gracious. Thanks for answering our questions. And again, if you guys want to check out Anderson Business Advisors, just go to retipster.com/ABA. And you can get connected to our affiliate link. And thanks for watching. See ya.